Good afternoon, everyone. I'm Jason Vitello. I'm the Director of Health Equity for CPHA. And thank you for joining us for our monthly CPHA Health Equity webinar. We have with us today Allison Neswood, Esquire. She's a healthcare attorney for the Colorado Center on Law and Policy. She advocates for policies that improve access to public benefits and provides policy expertise to advocates and community groups working on social justice issues. She's an expert in public health insurance plans, including Medicaid and CHP+, aid to the needy and disabled, immigrant access to services, and health equity. Thank you so much for being here, Allison. Today she will be presenting public charge and its impacts on health. And then at the end, we'll have some time for Q&A that Marissa will facilitate.
Great. Thank you so much for the introduction. Thank you for having me to present on this webinar today, the Colorado Public Health Association, and to everybody that's on this webinar that's tuned in to learn about the public charge rule changes. This is a really important topic that I know a lot of our communities are really worried about, and that is already having a lot of impact or negative impact in our communities. So it's an important topic to learn about. As was mentioned, I work at the Colorado Center on Law and Policy, and we work primarily at the state level to advance access to healthcare and economic security for low-income families in Colorado. And while we do work primarily at the state level, we also engage in federal regulatory change processes like this public charge issue deals with, when it will really impact health and economic security in our communities here in Colorado. And so public charge is one such topic, and that we've done a lot of work around to get the word out about it, to facilitate participation in the comment process when that was going on, and then just to help people sort of share accurate information with community members. So during this presentation, I'm going to provide an overview of what public charge is, what the Trump administration is proposing to do with it, and then just provide a few comments about its impact on health and how we should be thinking about talking to communities about what's going on. So I'll just jump right in. Uh-oh, this slide is not advancing. Okay. So under current law, the public charge is a term used in the immigration context to refer to a person who is primarily dependent on government cash assistance or institutionalization for long-term care. And that primarily standard means that the individual is dependent on government for the majority of their support or over half of their support. Cash assistance refers to programs that provide a cash benefit to recipients. Examples include TANF, which is a traditional welfare program, or Supplemental Security Income, or SSI, which is a federal income support program. And institutionalization for long-term care, of course, refers to, for example, when Medicaid pays for somebody to live in a nursing home or other institutional setting. So this is the current standard that's used for public charge. It's a pretty high standard. Again, the person has to be dependent for over half of their support on these two types of programs, or one of these two types of programs. So under current law, the public charge concept is used or assessed at two places in the immigration system. First, it's applied when somebody applies to adjust their status to become a lawful permanent resident. And that term, adjustment of status, refers to somebody who's in the United States, has a temporary status or other status, and then is applying to become a lawful permanent resident. The public charge test also comes up when somebody is applying for a visa to enter the United States, regardless of the visa type. And if an immigration official determines that the individual is likely to become a public charge in the future, the individual's application for adjustment of status or to enter the United States may be denied. And it's important to note that these two processes are actually governed by different sets of rules. The adjustment of status process is administered by the United States Customs and Immigration Service, or USCIS, in the United States, and that's under the Department of Homeland Security. So DHS has its own policies for how to implement public charge, and then the applications to enter the United States, or for visas to enter the United States, are actually governed by, or actually processed by consulate offices abroad. And they have to follow guidance from the Department of State called the Foreign Affairs Manual. And there's a public charge assessment outlined in that guidance. So the change that is going through the federal regulatory process right now has to do with the USCIS, or the USCIS process that applies to people who are in the United States changing to lawful permanent resident status. And so these next several slides are going to focus on that. And I'll also address some of what's happening with the Foreign Affairs Manual, or FAM, as well. But I'll start with the USCIS process. So under current policy, again, for the USCIS process, immigration officials are required to look at a range of factors. They're listed here. They have to consider age, health, family status, financial status, education, and skills. And for most people who immigrate to the United States, they have to, with a green card, they have to, or for most people, who are adjusting status to get their green card, they need to have a family member or other entity sponsor their immigration or their status. And in order to do that, the sponsor has to sign this affidavit of support, which essentially, or basically, attests to having a certain amount of resources and the ability to support the immigrant if that would become necessary. Under the existing test, USCIS can, or immigration officials can only consider receipt of two types of public benefits, and this is connected to the standard for public charge. They can only consider receipt of those cash assistance programs or of institutionalization for long-term care. In terms of things to keep in mind about this policy, there are restrictions that are, or requirements that are set out in the statute about public charge that can't be changed sort of unilaterally by the, not unilaterally, but through the regulatory process by the administration. First is that the test is not applied during the citizenship application process. So once somebody, has their green card already, public charge is not going to come up for them unless they lose their permanent resident status for some reason. That can happen when somebody leaves the country for more than 6 months and they're determined to have abandoned their status, when others are sort of very uncommon circumstances. But otherwise, if somebody's just maintaining their green card status in the United States, they are not going to be assessed for the public charge again. And it does not come up during the citizenship process. Also, not all immigrants are subject to the public charge test. Many of the groups that aren't subject are those that have entered with statuses that are generally granted for humanitarian reasons. So this includes refugees, people granted asylum, individuals with visas for survivors of trafficking or domestic violence, people with temporary protected status. So when those individuals are applying to adjust their status to get permanent residence, they're not going to be subject to the public charge test. If any of these individuals does lose their status for whatever reason and leaves and then comes back with a different status, a regular temporary, like a temporary work status or student status or something like that, and then they apply for their green card, the public charge test will apply. But in general, for most people, if they come in as a refugee and then they apply for their green card, public charge can't apply to them. The decision is forward-looking, so it can't be based on what happened in the past, or can't be based only on what happened in the past. They look at the range of factors to see what's likely to occur for you in the future. And then also no single factor determines whether a person is likely to become a public charge. All relevant factors must be considered. And this is called the totality of circumstances test. So for example, if somebody does, use a cash assistance benefit, but, has a well-paying job, has an education, is supporting their family, then all of those things have to be considered, and the use of the benefit won't determine the outcome necessarily. So in terms of what's happening with public charge with the USCIS process, on October 10 of last year, the Department of Homeland Security published proposed public charge regulations in the Federal Register. And that publication started a 60-day public comment period that was open until December 9th. And there was a lot of engagement across the country on this issue, and advocates were able to drive, and communities were able to drive a huge number of comments. In total, over 200,000 comments were submitted in a sort of non-scientific review of those that were posted to the public website. It looked like they were pretty overwhelmingly opposed to the rule, so that's at least positive, though not determinative. But in terms of the process, the department has to review and respond to all comments submitted. And then after that, if the department decides to move forward, they'll publish a final rule in the Federal Register. And the rule will not, because of the sort of magnitude of the changes or impact of this type of rule, it wouldn't be able to take effect until 60 days after that. And so I like to emphasize this point because one important talking point for families is that this rule isn't in place yet. Nothing has changed yet. And even if the department decides to publish a final rule, we're gonna see that publication and be able to see what's in there and what the final rule looks like, and still have 60 days to really educate communities what it's about, so that families can make informed decisions going forward. In addition, after that 60-day time period, litigation may further delay implementation. There's a lot of work sort of with national groups sort of planning what that will look like. And there's likely going to be some form of litigation once the final rule is published. In terms of what's in the rule, in the proposal, the big change, or the big overarching change, is that the proposal proposes to broaden the definition of public charge. So instead of having that kind of high standard for, you use over half, or you receive over half of your support from these two types of government programs, it's instead going to mean that you use just using a pretty minimal amount of public benefits as defined in the rule. And so under the proposal, the definition of public benefits includes non-emergency Medicaid. So that's just the general Medicaid program. It doesn't include emergency Medicaid. And it also wouldn't include school-based services that are funded by the Medicaid program. But for the basic Medicaid program, where people go to the doctor and the services are paid for by Medicaid, those would be included in the public benefits under this rule. Medicare Part D low-income subsidies would be included. This is a program that helps the low-income seniors pay for prescriptions. Federal housing assistance programs would be included, including Section 8 housing, rental assistance, and subsidized housing. The Supplemental Nutrition Assistance Program, which is the federal food assistance program, would be included. And then it would continue to consider state and federal cash assistance programs and government-funded institutionalization for long-term care. The proposal is explicit that no other public benefits or no other government programs besides those lists that I have listed here would come under the definition of public benefits for the purposes of the public charge assessment. And so it's just this list of benefits. In terms of the level of public benefit use, in order to be a public charge, The person would have to use for monetizable benefits or benefits that can easily be converted into cash value. The person would have to use just over 15% of the federal poverty level of the benefit in 12 months. So that's just, $1,000 for a household of one, $1,800 in a 12-month period. So it's a small amount that would raise to the level of public benefit. For non-monetizable benefits, this is like Medicaid, which is not easily, the value of the benefit isn't easily converted into a cash value. It would be 12 months of use in a 36-month period. So if somebody used it for 6 months in year one and 7 months in year two, then that would qualify as a public charge under the proposed rule. In addition, let me go back to this for a second. One thing that one question that we get a lot is, aren't people who don't have their green card not eligible for these benefits? And for the most part, that is correct. So one exception is that pregnant women and children with a broad range of legal immigration statuses can actually qualify for Medicaid and CHIP in Colorado. So, pregnant woman with a temporary student visa, if she received Medicaid services and then later applied for her green card, that under this proposal, if it went into effect, that would be considered under the public charge test. But in general, most of these programs are not going to be utilized by people who haven't applied for their green card yet. But what we're really concerned about is, people don't know that, and they think that either that any use of these benefits, even after they have their green card, will impact their citizenship, or that their use of benefits will impact other people in their household. And so we see this thing called the chilling effect, where people just are deterred from utilizing these programs, even though it wouldn't necessarily harm their adjustment of status application. The part of the rule that is really going to bar a lot of people from coming into the United States is changes to this totality of circumstances test, which puts more barriers in place for people who are low income or who have health issues or who don't speak English. And it does that by one way it does that is by giving extra negative weight for several factors. If the applicant's household income is under 125% of the federal poverty level, regardless of whether the family used or the person used any public benefits at all ever, if it's under that level or below that level, then they're going to have a hard time getting through the public charge process. If the person has some sort of work authorization, but is unemployed at the time that they're applying, then that will receive extra negative weight and they'll have trouble getting through the public charge process. If the person used public benefits or as defined in the rule, so any of those listed on the previous slide, within the previous 36 months, that'll be given extra negative weight. And if the person has any health conditions that will impact the ability of the applicant to work and that are likely to result in significant treatment costs, and that then that can count heavily against them unless they can demonstrate other means to pay for the costs of that potential, or pay for those potential treatment costs. They do give, the proposal does propose to give extra positive weight to one factor, and that's based on income. If the household income is greater than 250% of the federal poverty level, then they can get some extra positive weight. So in terms of, so one thing I want to lift up is that, there's been a lot of reporting of this policy or this issue in the news, and there was reporting on it before the change proposal that was published in the Federal Register came out, because there were drafts that leaked to the media. And those drafts were actually, the rule is troubling in itself, but were even more troubling especially in a couple ways. The first was that it included a wider range of public benefits, and it was kind of an open-ended standard. It explicitly included things like the Earned Income Tax Credit, WIC, the Food Assistance Program for women, infants, and or for new mothers, for pregnant women, and for infants and young children. And it also explicitly included free and reduced price lunch programs. And then again, like left the standard kind of open to other public benefit programs. And so it wasn't really clear what would all fall under. But those programs, the EITC, WIC, free and reduced price school lunch, are not included in the proposal that was published in the Federal Register. So they won't be considered in the public charge test if the rule passes or if the rule is implemented. In addition, something that was very troubling about the leaked draft was that it said the public charge test was going to consider use of public benefits by other members of the household, including dependents. And so, 1 in 4 children in the United States has a foreign-born parent. A very large percentage of those, I think like upwards of 80% of those, are citizens and fully eligible for public benefit programs, and their utilization of benefits under the leaked draft would have been considered under the public charge test for people. And so, if mom or dad was still trying to get the green card, they would have been deterred from accessing Medicaid or SNAP or other critical programs for their children. Of course, we see that families are still being deterred for that reason because of because of the chilling effect, because there's real fear over what this policy is about, and not because it's so complicated, is not a lot of really detailed understanding of what's included and what isn't. Let me see, do I want to say anything about that? So that's the situation with the USCIS process. For applications to enter the United States, whether it's a visa for a temporary student visa or a temporary work permit, or for a green card right away when somebody's entering, those applications are processed by consulate officers, foreign consulate offices, under Department of State guidance called the Foreign Affairs Manual. And there were actually changes made to this. These changes were pretty unilateral. The Trump administration was able to do this without going through a regulatory change process. And the way things had been before the changes went into effect, really almost immediately after Trump went into office, the way things were is that, if the affidavit of support was provided and met the requirements of the affidavit of support, that was generally all that the offices required to establish that the visa applicant was not likely to become a public charge. So as long as somebody was sponsoring the person, and as long as they met the sponsor met the income requirement, which is being at 125% of the federal poverty level, and as long as they attested to being available to support the immigrant in the event that was necessary, then the public charge test was pretty much satisfied under the consulate processing process. But but as I mentioned, some changes were made to the Foreign Affairs Manual. It didn't change the overall standard for public charge. It's still that receiving over half of your support from government cash assistance or institutionalization for long-term care. But it puts some more requirements, or requires consulate officers to look more closely at the financial status of the person who is applying for the visa. They're not just looking at the sponsor's situation anymore. And that assessment includes a potential look at benefits received by the visa applicants or their family. It's not totally clear how how uniform implementation of this policy is across the consulate offices, but we have seen visa denials based on public charge grounds rise by 3 times from 2017 to 2018. There has been litigation filed on this. It started with Baltimore litigation, and 20 state attorneys general have filed amicus briefs in support of the litigation against these changes. So we'll be watching that to see how it goes. Again, these changes in the Foreign Affairs Manual only impact people who are coming in, applying to enter the United States. These changes don't impact people who are living in the United States, who are applying for their green card here. So that's the Foreign Affairs Manual. And so I also wanted to just touch on, the impact on health. There's a lot of information out there, or, as this rule was being talked about in the media after the leaked drafts came out, and then the public, and then the Federal Register publication, there was a lot of fear being generated in immigrant communities about how this would impact their immigration status and their ability of their ability to keep their families together. And we started hearing reports very early of people, declining to access services. Service providers were seeing this. Advocates were hearing this from their communities. Community organizers were hearing this from their communities. And we began to look at sort of the numbers of people that this might impact. Overall, there are 41.1 million people who live in households with at least one non-citizen. And while not all of these individuals are would be impacted by the letter of the proposal if it went into place, a lot of people, because of the chilling effect, are afraid that it will anyway. In a recent study that has looked at the chilling effect thus far, found that 1 out of 7 adults in immigrant families reported avoiding using public benefits for someone in their household. We've also seen that participation in SNAP, the Federal Food Assistance Program, among immigrants fell 8% from 2017 to 2018, even though unemployment among the group remained the same. In the WIC context, nearly 2/3 of WIC providers surveyed in another study from 18 different states reported a decrease in immigrant utilization of the program. Even though WIC isn't included in the public charge proposal and wouldn't be, use of it wouldn't be penalized under the public charge assessment. And of course, declining to use these programs like SNAP and Medicaid means that people are going without nutrition assistance. It means that they're relying on cheaper food or cheaper calories, which provide less nutrients. And you are foregoing or delaying care, which can have really serious health consequences. And so if we even just look at food insecurity due to loss of SNAP, this has really serious health consequences. Food insecurity is associated with lower birth weights and higher infant mortality, higher rates of obesity in children and adults, increased risk of diabetes, increased risk of heart disease and high blood pressure, and higher levels of stress, anxiety, and depression in adults and children, in seniors. So we're really setting up a large segment of our population in a range of citizenship and immigration statuses to experience some really severe health consequences. And it compounds other consequences. The loss of SNAP, for example, compounds other consequences. If people are foregoing healthcare because they don't have health coverage, then that can have serious health consequences. There's also just increased toxic stress from financial insecurity, from fear about what immigration, for fear just of straight negative immigration consequences and the loss of the ability to keep your family together. Loss of housing and housing security. And so all of these things are really we're seeing these in our immigrant communities, and our providers are seeing them as they try to meet the needs of their patients and other members of their community. In terms of talking to families about this, I stress a few things. One is to make sure that families know that the public charge test does not apply to all foreign-born people. It doesn't, again, apply to people who already have their green card. It doesn't apply at the citizenship stage. I get the question a lot about whether it applies when somebody is renewing their green card. It does not. That's not considered an adjustment of status. So it's just that when they're applying for their green card for the first time. Again, it doesn't apply to people who entered in one of the several statuses granted for humanitarian purposes. The next point that's important to make is that the rule is just a proposal. It's not in effect yet. And importantly, the proposal explicitly says that the policy won't be applied retroactively. So that means, a person who uses the public benefits all the way up to the day before the rule goes into effect, that utilization will not be considered in any public charge test that's implemented after the rule goes into effect. So there's not really benefit to dropping benefits at this time for families. The next point that I would make, that I really stress is, for the USCIS process, public benefits used by dependents or other members of the household are not considered would not be considered during the adjustment of status process, either currently or in the proposal. So this means, when for an individual who has perhaps a temporary visa and they have children who are citizens or otherwise eligible for benefits, if their children use benefits, they're not going to be penalized when they apply for their green card through the adjustment of status process. Finally, the last point I want to make is that, or that I think is important to make, is that the use of a public benefit itself is not determinative. Immigration officials still have to look at the totality of the applicant's circumstances. And as I sort of summarized earlier, these programs can have a real impact on individuals' ability to have health and then all of the consequences that come from that, to maintain employment, to take care of their families. And so public benefit programs can really help families improve their financial situation, so that they can have as strong an application as possible during the public charge process. Because remember, as I mentioned before, they're still going to look at income level, they're still going to look at health status in a really critical, much more critical way under the proposal if it's implemented. So I think that's an important thing for families to be considering as they're making these choices. That's all of the content I have for this presentation, and I'm really happy to answer questions. I see that the comment light is blinking, but I'll just pause to see what the process for answering questions is. Oh, wait, I'm sorry. Let me say one more thing. Our organization works in close partnership with the Center for Health Progress and several other organizations on the Coalition for Immigrant Health. And that coalition has put together some documents that are really designed at helping providers and organizers and other sort of community resources or talk to members of their community about the public charge proposal and what's going on. And so if people want access to those resources, just definitely get in contact with me, or whatever other process makes sense I'll make sure that people can get those.
Wonderful. Thank you so much, Allison, for your time. Can you hear me okay?
Yes, I can.
Okay, sorry everyone. I didn't realize that I had some audio issues at the beginning, so I apologize for that. But we'll go ahead and launch into Q&A. So really appreciate you sharing, Allison. We had several clarification questions come up throughout the talk that a few folks messaged me as well. So I'll go ahead and start with those, but if anybody else would like to add a question, feel free to type that into the chat box. Also, as soon as I'm done reading through the questions and having Allison answer what we got so far, we'll also open it up. So you're welcome to ask a question through your own phone line as well once we get through these few questions. So the first was a clarification on who's eligible for Medicaid and Medicare. So do you mind clarifying, Allison, when you were speaking about that part of the talk?
Sure. So in general, people who are immigrants that are eligible for Medicaid include immigrants that have a status that is part of the definition of qualified alien is the federal language, but that includes people with their green card, and then the refugees, asylees, people with other humanitarian statuses. For people with their green card, however, there is a 5-year waiting period in general, meaning people cannot be eligible for Medicaid until 5 years after they enter or get their status. But that 5-year bar, they call it, doesn't apply to children and pregnant women. And so, you know, a pregnant woman who's had her green card for 1 year can qualify for Medicaid. A child, regardless of how long they've had their green card, can qualify for Medicaid if they meet the other, you know, income requirements that apply. In addition, I mentioned that children and pregnant women in a broader range of immigration statuses can qualify for Medicaid. So while in general, like for adults, in general, you have to be in one of those quote unquote qualified alien statuses. For pregnant women and children, they could have a temporary status. They could be have a temporary work visa, a temporary student visa. So in general, adults with those kinds of visas wouldn't be eligible unless it was a pregnant adult. For children, if they had this sort of child visa that goes with the temporary work visa, then they could also qualify for Medicaid. In terms of Medicare, oh, sorry.
Yeah, no, go ahead, please. Yeah.
Yeah, in terms of Medicare, Medicare is a program for seniors and people with disabilities. So it's a program for people who are 65 or older or who are disabled, who have 40 quarters of qualifying work experience. And that just means the reason for that is that somebody, you know, paid into the Social Security / Medicaid system for at least 40 quarters, which is about 10 works out to about 10 years of work. And yeah, I'm not as much of an expert in Medicare, but those are the basic requirements. They also have
Thank you.
Yeah.
That's great. And then we have 2 more specific questions about whether the assessment would include, for example, someone asked about I-130 visas for spousal visas. For example, they mentioned if a U.S. citizen was petitioning for someone who is low income.
Yes, it would apply to the person who is being petitioned for in that circumstance, and they would look at the person who is immigrating. They would look at their financial status. Does that answer the question?
Yeah, and then similarly, someone asked about the probationary 2-year period of the green card and how that might impact this.
For the first, it's not assessed again. So somebody will get their apply for the probationary green card. That's when the public charge test would apply. It wouldn't apply again after the 2-year probationary period.
Great. And then this is a question about your conversation from discussing the changed rules at the State Department. So someone asked, who makes the decision about whether the rule applies? Will consulate offices be involved? Are existing State Department employees making these choices, or will new individuals be hired?
I'm not sure I totally understand the question, but in the foreign consulate offices, there's a lot of discretion. The Department of State writes the Foreign Affairs Manual to provide guidance to what the consulate officers do, and they have a lot of discretion, honestly, in how they implement those policies. Unfortunately, as we see in the USCIS regulatory change process, there has to be a public comment, or public involvement, public comment, and then consideration of those comments by the administration. There's not that involved of a process. There's not an involved process that's really overseeing the change. The process of really objecting to what happened is going through the courts, and trying to say that basically that this is a huge change and it shouldn't be happening without or unilaterally at the administrative level.
Great. And this is probably a similar question. Someone else asked, how does DHS plan to implement this evenly?
Evenly. I'm not sure I understand the question, but you mean in different USCIS, or perhaps the question means how is it going to be implemented uniformly in different USCIS offices? I think that's
yes.
you know, a common problem in immigration law, that immigration officers do have a lot of discretion in how they implement policy. Having them the proposal though does really prescribe things pretty specifically in rule, and so you know there would be a lot of guidance and regulation that hasn't been in there before, so perhaps less discretion, but the rules aren't good, and so I don't know if that's necessarily a huge positive, except for perhaps maybe giving people more notice about what's going to happen.
Thank you. And then the next question was about resources available. Have there been resources available in English and Spanish for community members, as well as for service providers to navigate public charge and thinking about access to services?
Yes, and what I mentioned at the very end about the Coalition for Immigrant Health Materials, all of that stuff is available in both English and Spanish. And if people need resources in other languages, we can work on that as well. Just let us know. And so I'll work with you on how to sort of get those distributed to the people who would like them, who need them.
Great, wonderful. And then the next question was about consideration of other programs. So some examples were Pell Grants, federal loans, Head Start, and free and reduced lunch.
Yeah, so under the proposal that is that the Trump administration published in the Federal Register, or the DHS published in the Federal Register, none of those programs would be considered in the public charge test. It's only those ones that listed on that I listed on the slide: Medicaid, Medicare Part D, housing assistance, food assistance, and cash assistance, and institutionalization for long-term care. And it's very explicit that no other programs will be considered.
Great, and so that probably answers someone else's question who asked specifically about HIV diagnosis and accessing Ryan White funds, for example, knowing that it's a lifelong chronic illness with expensive drugs.
So actually, my response doesn't really answer that question. So for that question, use of the program wouldn't count against them in the public charge test, but the illness or the condition would. And that's really one of the real ugly things in this rule. It looks at a person, and if they're low income, if they're sick, then it will make it much harder for that person to get through the immigration process, and much more likely to be denied on public charge grounds.
Wonderful, thank you. And then the last question that I had from the chat box, thank you everyone for submitting your questions, was a question more broadly about discrimination. So the question says, realistically, how secure can families be that there will not be discrimination if they access benefits, since historically there have been ways that institutions have found to discriminate in the country outside of rules or laws? So they gave some examples like employment discrimination or redlining.
Yeah, I mean, that's a really great question. And, you know, I think as an analogy in Colorado, we even see, you know, some of our families who maybe don't speak English or who appear to be, you know, of, you know, not white race are, you know, discouraged from even applying in some of our county offices, and are struggling to access services that way. And so I don't think we can ever fully guarantee that people implementing policies are not going to act on biases, whether they're unconscious or more intentional. But at the same time, you know, the rules are the rules, and to the extent that we start to act as if they're not there, then we lose their protection, I think. And so I think it is really important for families to know what protections are in place so they can, make the best decisions for themselves and pursue their rights. But again, I can't, none of us can fully guarantee that some of these uglier sides of our society don't rear their heads in problematic ways.
Yeah. Thank you. And as Allison mentioned, if you're interested in any of the materials thus far that she spoke about, I've entered my email in the chat box. So if you'd either like those English or Spanish materials, feel free to email me, as well as if you have any requests for other languages for that to be translated into as well, if you serve a particular community that needs to be aware of these potential changes. So those are the ends of the questions from the chat box. I'd love to open it up if anybody would like to ask Allison a question directly. So feel free, just be conscious of speaking over others, and feel free and unmute your phone line if you'd like to ask a question. Anybody from the phone have a question, feel free to unmute your line. Okay, well, Allison, it seems like we don't have any questions coming directly from the phone. So unless anybody wants to interrupt me as we're wrapping up, feel free. We just want to thank you so much, Allison, for your time today and your energy to do this work and share your work with us. We really appreciate all that you do and all that CCLP does. We're grateful to have more information to work with as we all serve the communities that we work in. So again, if anybody has any questions to follow up about this webinar, Allison's contact information is on the slide, or you're welcome to reach out to me if you'd like a copy of anything. So thank you again, everybody, for your lunch hour today. We appreciate it.
Thank you, Allison, again. I also want to announce that our next Health Equity Coalition meeting is July 22nd at 5 p.m. at Denver Public Health. If you're interested in attending,
Hey, Jason, we lost you for a second.
okay, I wasn't on mute that whole time, was I?
No worries. No, you were talking about the meeting time.
Yeah, the meeting is Denver Public Health, July 22nd at 5 p.m. We'll be serving dinner and unveiling the strategic work plan of CPHA, as well as the bylaws, which were greatly informed by the Health Equity Coalition. And we really look at it as a platform for us to kind of take what we learn in these webinars and from our general learning around equity, and it's a forum where we can hopefully apply what we've learned into really operationalize equity in our in the systems we work in our communities, and ultimately in the legislature.